pieces of natural water. This is ocean, this is Lake Okeechobee. As Lake Okeechobee goes up or down when it's 14 feet high or when it's 11 feet high, huge difference there. The state owns all of it. Not the upland owner, but the state.
Other than the obvious, is there a practical reason why the state owns that, or they want to have that?
Because the Constitution says so.
The Constitution of the state of Florida.
And the state will not deed it to people. This is an oversimplification, but the big shot hotels on the beach in Miami that say that you can't walk on their piece of the beach, they can't do that.
Gotcha.
Their big muscle men can probably keep you off, but you can sue them to have access to the beach. Now, water between where the high tide comes, the beach is an oversimplification because the state owns all the beaches, period. In addition, even above the high water line, there are statutes that say all beaches have an easement in favor of the public all the way up and down the entire beach, and nobody can put a fence on extending their lines down into the ocean and saying you're stopping here. But it's the same concept, that it's public lands. And really, when I say state lands, that doesn't mean that the state has a deed. It just means the state regulates it, and you don't own it, and you can't build on it, but they're not going to deed it to you because it's public land, just like they're not going to deed parks or anything else. Yes, sir.
So riparian rights in the waterways, so like say the intercoastal, and you have riparian rights for 80 feet, so you can build a dock, 80 feet out into the intercoastal. How's that work then?
Well, the dock is a bad example because it's highly regulated by the Department of Natural Resources in Tallahassee, and secondly by the Army Corps of Engineers when you get into the intercoastal, because the Army Corps of Engineers controls the entire intercoastal. So to put a dock out there on the intercoastal, you got to get permits from both of them. And that's why you see most people really on the intercoastal don't have docks. Just the guys going up the canals do. But out on the intercoastal, they usually don't. Riparian, what riparian means
Riparian, like riparian
it does
water
not
rights.
necessarily mean that you own the water or that you own the land under the water. It means you are the waterfront land owner and you have water rights.
Okay.
That's what it does not mean you own the bottom.
Yeah.
Okay. It means you have the right to, for example, keep people who come on the canal from getting off onto your property because you control that piece of waterfront. Doesn't mean you own it. Doesn't mean you can build on it. Doesn't mean you can move your seawall 10 feet out further.
Okay.
But it does mean that you control the water rights that belong to that piece of property.
Okay.
Okay. Yes, sir.
How much mile do you have from your property to the water rights? Like, what's the amount of miles you're entitled to?
The amount of what you're
Of
entitled to?
miles, like 50 miles from your house, or how is it?
Well, what it means is you control the shoreline. No, it does not mean that you control 50 or 100 miles out into the center of a 200-mile lake. It means you control the water rights adjacent to the adjacent, meaning incident to that parcel, and the right to regulate what happens on the shoreline, but not beyond that. What we're really going to remember what we talked about. It's not so much that you own it in the wonderful sense of I own it, but it's what can you do with it. And with waterfront property, you can get a permit and have a dock. You can beach your boat, you can fish, you can do all the wonderful things that go with whoever owns the waterfront, but that's not the same thing as I own title to the bottom and that I can issue a deed to the bottom or that I can control things 15 miles out in the middle of the lake. It's not really you get to control the water. It means you get to use the water and they have the water rights that belong to that piece of property. Other question? Okay. That's called riparian rights. And the lands that are on the water, riparian rights are the rights to have the benefit of the water, and riparian lands are those lands that are on the water. Riparian lands just means waterfront land. Now, there's a whole bunch.
Before you go on,
Sure.
is there any, for example, the fact that the government owns that middle ground, does that have any impact if you need to repair a seawall or if you need to build a new seawall? Do you need to get
You have to get
permits?
You have to get permits for all this stuff.
Right, but I mean,
can't
like a special permit, do you just go to the city and get a permit, or do you have to go to a special place to get a permit since this is this type of,
It depends on where you are. If you're on a private lake, you may have to get a permit from the local water management district. You may not be in a municipality, you may be out in the country somewhere. But there's virtually nothing you can do on waterfront that you don't have to get a permit from somebody. Army Corps of Engineers, Department of Environmental Protection in Tallahassee, the DEP, or the local water management district. And we're going to talk about the water management district in just a second. But you really can't go put a pier out in the middle there and say, oh, I own the waterfront, so I get to put a pier all the way up. You're over the state lands, and to that extent, you're going to have to get a permit from somebody, but it may not be the state. And maybe they have vested that authority in some local authority to do so. But building a dock is just like any other kind of construction. You still got to get a building permit from the local building department because you're building a structure.
right?
It may mean that you need additional permits because you're doing it on the water. But you always got to get local building department permits and inspections and all the stuff that you get when you get a house permit.
No, I was just thinking of the actual seawall. You know, if you have a property that goes all the way to, say, to a ravine or some, you know, where you have the sea coming into
The
it.
state has lots of rules on
Like,
seawalls.
Star Island.
They're now encouraging riprap now, and a lot of times they require riprap, you know, that's piles of rocks outside your seawall.
Right,
Because
okay.
they want to generate mangroves growing and fish swimming in the rocks and stuff like that. So it is a very highly permitted area, but I can't personally tell you what permits you need to do X, Y, Z on A, B, C piece of property. Architects can. Really, the guys who know this the best are the seawall contractors. You call them, they know who to get the permits from, because if they do a job that they didn't have the proper permits, they get shut down in the middle of the job and they don't get paid. So they know who you have to have. Okay, now, we're not going to talk at length about all of these different wonderful waterfront theories that the book talks about in the eastern states and the western states, and riparian theory and prior appropriation theory and all that. I want to make sure that you understand where I'm coming from. I'm not saying that water law is not important. Water law is not a big deal in Florida, even though we have so much waterfront. It has not been a highly developed thing like it is in agricultural areas where you're fighting over the flows of streams in order to irrigate your crops because your crops are going to die. We just don't have that much water law in Florida. And therefore, I don't think it's worthwhile to study this law in the western states and compare it to the eastern states and these different doctrines of natural flow and reasonable use and all that stuff. I just don't think you're ever going to hear about it. What you need to know is anything you're going to do on the water, you're probably going to have to get a permit. You're going to have to get it from the local water management district. Here in Florida, it's the South Florida Water Management District, or from the Florida DEP. We have a whole section in the Florida statutes, chapter 373, called the Florida Water Resources Act of 1972. Water is regulated in Florida. It's just that, candidly, when it's time for you to develop waterfront property, you're going to need to see somebody who knows what those rules are. I don't know enough of them to teach them to you, and I don't think you want to try to learn them to do as a do-it-yourselfer. Just understand, basically, if you own waterfront property, there's going to be a lot of permitting involved before you can do anything physically with it. And your contractor's probably going to be your best advice on that. That's surface water. There's another whole section in the book on subterranean water. And that's all about the streams flowing underground. And that's our underground aquifer here that's at 80 or 90 feet down that is the source of drinking water that feeds out of the Everglades. There are different laws in different states regulating subterranean water. In Florida, we follow one of their use rules in that whole section. But candidly, I just don't think it's important. We've got underground water, we've got underground streams, we've got all this stuff. I honestly don't think it's worth your while, or my while, to get off too heavily beyond what we talked about. Knowing the term riparian, knowing you're going to have to get a permit somewhere to do anything with it. That doesn't mean you own the bay bottom, it just means you have the right to the water frontage and the right to use the water, probably subject to a permit. I want to move to mineral rights for a minute for two reasons. Number one, to talk about mineral rights. But number two, to talk about a concept that this is the first time we're going to deal with the way of creating these rights that I want you to learn and understand, because it's going to apply to a half a dozen things that are going to come up later. But let's talk about what mineral rights are first. Mineral rights are the rights of the surface owner to all the minerals that are on the surface or under the surface. They're not going to be any up in the air, but they're going to be minerals either on the ground or under the ground. If you own the surface, you own the minerals. Understand that you can separate the ownership. You can transfer the mineral rights to somebody else, but still own the piece of property. This is one of the first ways that we're going to talk about that you can kind of bust up ownership. You can transfer the mineral rights to somebody else. You can still own the land. Somebody else owns the oil or the natural gas or the diamonds and rubies or whatever you got under your land. Now, there are 4 ways to separate the mineral rights from the surface rights. The first 2 I want to talk about at length because they are going to apply to a dozen things that are going to come later. You own the surface, you own the piece of land, you can give a mineral deed to somebody else. That's a deed. A deed is the document with which you transfer title of property or transfer rights in property. You can give a mineral deed to somebody else, or you can sell a piece of property to somebody else and reserve the mineral rights to yourself when you transfer the property. Now, I want to go through that again because those concepts are important. We're going to see this in a lot of cases. You either transfer away the rights, in this case that's called a mineral deed, or you transfer the property and you reserve the mineral rights, that's called a mineral reservation. Transfer a deed, or transfer the land and reserve the rights, that's called a mineral reservation. So those are the 2 basic ways that you transfer rights to minerals. And I'm going to relate back to that when we stumble into some more concepts that happen exactly the same way. There's a 3rd way and a 4th way. These don't happen very often in Florida. There's a mineral lease, where you lease the minerals to somebody. But you don't transfer the ownership right. You lease them. And the way you get paid your rent is royalties. As the guy you lease the mineral rights to takes out the minerals, he pays you 10% of them. That's your rent. That's a mineral lease. You're leasing the rights to the minerals. You didn't transfer them away, but you leased them to somebody. And in rent, you get paid a piece of what he takes out. And the last one is called a mineral rights option. And all that is simply you give somebody the right to come explore on your land. Start digging holes looking for minerals. Start drilling looking for oil. That's called a mineral rights option. Then if he finds some, then there's a built-in provision to how you're going to make a deal. You're going to sell them to him, you're going to lease them to him, what are you going to do? In other words, nobody's going to want to come explore for minerals on your land unless they know they got a right to keep them if they find them. So the point is, a mineral rights option is you give somebody the right to come explore, which will naturally lead to another deal to either share royalties or to sell them the mineral rights. The important things are the first 2. A mineral rights deed, where you deed the minerals, or a mineral reservation, where you deed the land, you retain the minerals. Okay, now, the next section is oil and gas. Not saying we don't have any in Florida. We do. But we don't have a lot of Florida law about it. And you're not likely to get involved in an oil and gas deal in Florida. But in Texas and Oklahoma and places like that, I mean, this is just big time volumes of law and court decision and all. And the reason for it is pretty obvious. If you've got this piece of land, and the guy next to you has this piece of land, and this guy drills an oil well, the issues are all about, what if he's sucking up your oil? That's what they fight about. The oil is down here. And their law says, basically, this guy owns this oil, and this guy owns this oil, and it's all in this pool.